But what is income? As I said at the opening, income is one of those words most people understand from its common usage. According to Merriam-Webster, income is a gain or recurring benefit usually measured in money that derives from capital or labor. As much as you may curse tax day, complain about the withholdings on your pay stub, or dream about abolishing the IRS, the states ratified the 16th Amendment, allowing Congress to directly collect taxes on your income. While federal politicians and bureaucrats have tried to tax wealth rather than income in the past, they have never succeeded. Well, not yet at least. The argument from the attorney for Mr. Morse started with, the word income is not an inkblot. Income was understood at the time of the 16th Amendment's adoption to refer to gains coming to the taxpayer like wages, rents, and dividends. Appreciation in the value of a home, a stock investment, or other property is not and never has been taxed as income. The reason is that a gain is not income unless and until it has been realized by the taxpayer. It is undisputed that the petitioners realized nothing from their stock investment. They were not taxed because they had any income, but because in 2017 they happened to own shares in a corporation carrying retained earnings on its books. This is a tax on the ownership of property and therefore must be apportioned. The court should reaffirm that there is no income without realization. These words of Mr. Andrew Grossman, the attorney for Charles Moore, seem to be pretty straightforward. As you would expect, the government of the United States has a different view of income. The MRT is firmly grounded in the 16th Amendment's text and history. The amendment allows Congress to impose taxes on incomes. That phrase had a well-established meaning drawn from numerous pre-ratification income taxes that Congress enacted before this court's decision in Pollock. Several of those taxes were like the MRT in that they taxed shareholders on undistributed corporate earnings, including income taxes in 1864, 65, 67, and 70. And this court upheld Congress's power to impose those taxes in Hubbard. The 16th Amendment's drafters, therefore, would have understood taxes on incomes to include taxes like the MRT. Solicitor General Elizabeth Prelogar, arguing for the United States, claims that the MRT, or Mandatory Repatriation Tax, is grounded in the text and history of the 16th Amendment. She points to several taxes that considered undistributed corporate earnings as income. However, each of the taxes she mentions predated the 16th Amendment. She then claims that the drafters of that amendment would have understood income to include such unrealized gains. She claims that such pass-through taxation has been passed by Congress on several occasions, and that the courts have limited the case the plaintiffs are relying on, Macomber, to specific dividends. A stock dividend, evincing merely a transfer of an accumulated surplus to the capital account of the corporation, takes nothing from the property of the corporation and adds nothing to that of the shareholder. A tax on such dividends is a tax on capital increase and not on income, and to be valid under the Constitution, such taxes must be apportioned according to the population in the several states. Now, General Prelogar even makes an interesting claim. Finally, the court doesn't actually need to resolve any fundamental question in this case about whether the 16th Amendment requires realization. The MRT taxes income that was actually realized by the foreign corporations, and Congress permissibly attributed the tax on that realized income to U.S. shareholders, just as it has done in any number of pass-through taxes throughout our nation's history. The court could say only that and affirm. It appears General Prelogar doesn't think the court needs to decide the question of realization because the tax being challenged is against income realized by a third party.